We need to give time for the police to arrange for pleas. So those who don't have anything they are doing within, they can just wait from outside. Yes, we have, the name is Melvin. Yes. It was coming up for settlement.
Yeah, the bank representative was to confirm.
Yes, the prosecution had asked that we place aside.
Where did bank representative try to quickly come out? Of what day?
You're ready to put in the stand?
Yes, Your Honor.
We've taken over our business box.
I swear by the Almighty name of God that the evidence I shall give before this court shall be the truth, whole truth, so help me God. Your Honor, I am Kipkorir Kosgi.
The name is that?
Kipkorir Kosgi.
You have your ID?
Yes, Your Honor. I am an employee of Family Bank Limited, working as a security and investigations manager. And based in head office along with the Biko Street. Your Honor, I wish to confirm to this court that the accused person has restituted back to the bank in the case E007 of 2023. Authorizing me to withdraw the case.
You confirm that you have no other claim against the accused.
Yes, Your Honor.
And you are aware that once this matter is resolved, you will not
Correct, Your Honor.
Your Honor, is that one question?
So upon listening to Mr. Kipkoli Kosgei representing Family Bank, the complainant hearing, and there being no objection from the prosecution, the charge against the accused person is withdrawn under Section 204 of the Criminal Procedure Code, and he is acquitted. The right of appeal is 14 days. How was he released? Is there a cash bill? There was a title deed. So the security, the surety is discharged and the security be returned back. We need time to arrange for, please. Are you ready? We give you time to arrange for, please. Or are they ready?
Peter Ruben Baraka. Peter. Peter Ruben Baraka.
We are not ready. I can see senior counsel seated in the dock. And we need the dock.
We are in the same matter.
You are in the same matter.
Yeah.
We are living in dangerous times.
We need the dock for the accused persons. I wish, as we wait, I think the next open court is also free. Yeah, so
I'm told the file has been registered.
The file has now been registered. Okay.
That's what I understand from.
We'll be waiting for it.
Yes.
It has not arrived, but it will come to it once it's.
Yeah.
It's ready.
We will wait, Your Honor. Yes.
Peter Ruben Baraka. Yes. Crossing Ashford Bodringham. Particulars are that on 17th day of August, 2024 at around 15 hours at Arraigned around on Avenue, Nairobi, New Nairobi. One Richard Asemu by twisting him.
Is the prosecution opposing bail?
There's something that you do with what we cash bail. Perhaps 5,000 complainant is willing to have this matter reported, follow that you are sent up to court in court. I believe on the next trial date when we shall be having this matter taken up.
It's a plea of not guilty entered. Pre-trial. We have the master diary. Pre-trial will be on 3rd of September. Before this court. before this court. There is no objection to bail. Accused may be released. On bond of Kenya shillings 20,000 plus one security. Or cash bail, Kenya shillings 15,000 plus one contact person. Prosecution to supply the defense copies of all documents to be used at the trial. Yes, prosecuting counsel. I understand you're not ready for pleas. You've not received your files. How much time do you need?
10 minutes.
10 minutes. 10 minutes. So we come back at 11 to proceed on with the pleas.
You are coming.
You was having the file.
For which?
You was holding the file.
Let me call you Nasi.
No, it's on the court. I think you have a court. Like, I mean, the Bamba, he's putting his foot there.
I don't know how.
Acha nikienda nipige tu picha moja tu alafu sawa. Sasa kipige. Mama tu.
Karibu kapia mahali pa. No, it's still here. Hata enda sasa still here. Utapiga picha. Sasa mimi. Sasa kwenda. It's okay. I was so wait, what? Excuse me, what was it? Don't go there. It's still here. I think I should have on the I do.
You had the iron. You had one. So what are they telling you?
Unasema wewe kusoma kwanza kila kitu. Kila pande iko.
Usifanye hivi. Ya front shot ya macho ni kupata na unipatia. Ndio mimi niko na sauti zote. Niko na kupatia front shot. Niweke chini. Hivi ndio sasa.
I think that's the one that's taken here to file. Yes, but I think this is the one that's already in the court file. No, it's not. The one I've seen is the one which I've taken. But she has two files. In the court file somewhere there. So that they just confirm. Yeah, just confirm. Yes, I am. Yes, I am.
I just follow what you mean.
Shares that. Oh, for a few minutes to do the other one. You have to. They brought both the charge sheets. Okay.
Milimani, Wanjigi Wawero, and J.V. Awiti.
Morning, Your Honor.
Your Honor, for the suspects, for the record, Paul Muite, Senior Counsel Kalonzo Musyoka, whose brief I own. The Honor will recollect, he was here. The Honorable Mother Karua, Senior Counsel. Dr. John Hamino, I'm here, Your Honor. Mr. Gad Awoda, Mr. Nelson Osiemo, Owiso, Doctor.
Present.
Dr. Ekuru Aukot, the Honorable Eugene Wamalwa, Mr. Jakoya, Henry Karauka, name is Bashir, who is present. Your Honor, for the defense, I can confirm that each of the individuals whose names are given for the defense, each of them is an advocate of the High Court holding a practicing certificate. And it is in that capacity that we are here. Your Honor, the defense has an application to make before the plea is taken. And that application, Your Honor, is that we apply for the taking of the plea to be postponed to give us an opportunity to challenge in the High Court the bringing of these charges, for the reason that even as the accused or the suspect was being arrested, there were valid court orders issued by the High Court of Kenya, directing the suspect not to be arrested. Your Honor, we wish to raise the issue of contempt of court. Before the court that gave those orders. And act in violation of court orders. So we have solid basis for challenging the bringing of these charges. And Your Honor, it is our submission that this honorable court, in order to promote respect for the administration of justice, will indeed accord an opportunity where the issue of contempt of court orders is raised for the accused or the proposed accused to make that challenge before the High Court. Your Honor, let me clarify. There were two sets of orders issued by the High Court. First, there were orders issued that the accused should not be arrested. And the arresting of the accused was contempt violation of those court orders. If you can hand over the orders. Separately, Your Honor, that is a copy of the court order. Separately, Your Honor, there were orders issued by the High Court for the return of the guns confiscated from Jimmy White, which were licensed in a valid certificate to hold the guns. And the orders of the High Court were for the return of those guns, which were returned, but also
they were returned.
They were returned. to Jimmy Wanjigi in accordance with the court orders. But the further court order was for a reinstatement of the certificate to hold those firearms. We've handed over these copies. All those copies of the court orders are there, Your Honor. So the guns were returned. The further court orders were for reinstatement of the firearms certificate. Firearms as specified, set out in the order of the court. So, Your Honor, perhaps in an attempt to get around the court orders not to arrest Jimmy Wanjigi, we learned that despite the clear provisions of Article 47 of the Constitution, fair administrative action, despite the court order that say return the firearm certificate to Jimmy Wanjigi, the police decided, without any notice of any kind to Jimmy Wanjigi, to cancel the firearm certificate in order to charge him with being in possession of guns without the certificate. Now, Your Honor, as this honorable court is aware, before any adverse action is taken against anyone, the police were under an obligation under Article 47 of the Constitution to give a notice to the holder of that firearm certificate. That is what Article 47 is all about. That is what fair administrative action is all about. In order for him to be heard in his own defense before an adverse decision is taken. So we have these cogent basis and reasons for challenge the attempted charges. And Your Honor, before I hand over to my colleagues here, let me just say it is not just Article 47, because the Constitution is read as a whole, and it strengthens the submissions we are making that Article 47 is to be read with Article 10 of the Constitution that requires reasonableness, fairness, transparency by anyone taking any action. And of course, Article 2 that holds everyone subject to the Constitution and requires everyone to act in accordance with the Constitution. You know, we need to keep reminding ourselves of the transformative nature. We need to keep reminding ourselves of the transformative nature of the 2010 Constitution. It's not by accident. It was deliberate. Article 1 is about the sovereignty for the people of Kenya. That sovereignty is donated to the judiciary, to the executive, to parliament. but always the interests of the Kenyan people, of which Jimmy Wanjigi is a member, to be respected. Even the human dignity, which has got its own standalone article. All these are to be read together with Article 47. And finally, Your Honor, with a lot of respect, the people of Kenya in the 2010 Constitution donated their sovereignty to the judiciary and charged the judiciary with the responsibility of ensuring that everyone acts in accordance with the Constitution, respects the Constitution. That is what we are asking this Honorable Court to do by asking that the plea taking be postponed for at least 4 weeks in order for the accused to go back to the High Court to draw the attention of the High Court that its orders have been violated by the police, and that the police are acting in contempt of the court orders. I believe Willis will address the court. I thank you.
Your Honor, before you is Mr. Jimmy Wanjigi, brought to court.
Sorry, may I get your second name?
Willie Sakeno, Your Honor.
Yes.
Your Honor, before you is Mr. Jimmy Wanjigi, brought to court in handcuffs at the behest of the state, and they are seeking to invite you to admit a charge and invite him to take a plea on those charges. Your Honor, you are a court of law, a court that respects the authority of its own processes and the authority and orders of other courts within the Republic of Kenya. The applicants are inviting Your Honor to consider an order issued by Justice Bahati on the 9th of August 2024, which order is in specific terms. Order 2 speaks to an order directing the state, including IG, servants, their agents, from arresting Mr. Jimmy Wanjigi. Mr. Jimmy Wanjigi. The learned judge specifies, if by any chance you are detaining, you have arrested the DCI in honor of some. Have we gone to the state of the jungle? So, Your Honor, it is important that we bring every player before you, Your Honor, to order before we make even a single step in these proceedings. Everybody must accept and admit that we will submit to the authority of the courts and their orders whenever, wherever they are given, whether we agree with them or not. They cannot cherry pick. That for purpose of registering a charge against Mr. Wanjigi, we don't care about Justice Bahati's orders. And they want this court to now admit them. They want this court to even give them audience. They want this court to excuse their blatant breach of the orders of Justice Bahati. And as we speak, Your Honor, we have since filed a contempt of court application before the High Court against the acting IG and the Director of Criminal Prosecution and Mr. Michael Sang, who was in charge of the operation.
Against?
We filed a contempt of court application before the acting Inspector General of Police. He has brought to court his badge of honor as a disobeyer of court orders. He's brought it to court to show the court that orders don't matter. And Your Honor, when you retire to look at the orders we've shared with the court, it is in plain English. It is in plain and Your Honor rejects the invitation to entertain constitutionality from the beginning. The foundation of these charges is disobedience of court orders. Allow the High Court to deal with those questions. Then we'll come back before you, once the elections are given. No prejudice shall be suffered by the state or anybody. No prejudice. Mr. Jimmy Wanjigi is a non-citizen of this republic. His residence is known, has been raided more than 2 times. It's the raiding spot for the respondents when they are bored. So they can always find it. The 4 weeks deferment will not prejudice anybody whatsoever, but it will uphold our constitution and our commitment to the rule of law. The second point As I conclude, Your Honor, why we urge for deferment of the police. The issue of ownership of firearms by Mr. Jimmy Wanjigi was litigated before the High Court in petition 520 of 2017. And the court ordered the respondents.
Petition number?
520 of 2017.
Yes.
The court ordered the respondents to give him back his firearms. Your Honor, 3 years after the orders of the court, in fact, 5 years, the orders were issued in 2019, but until 2023 were those orders complied with.
The orders were issued?
Were issued on the 25th of June 2019. They were complied with sometimes in the year 2023.
Complied with in the year 2023.
Delete every app on my phone for this.
And just to create a completeness of that long journey, those 5 years, the High Court, in recognition of the authority of its processes and its orders, actually committed the former Director of Criminal Investigations, Mr. George Kinoti, to civil jail for 4 months for refusing to comply with these orders. So the respondents have a history The court also, Your Honor, in JR number 46 of 2018, which looked into the propriety of Mr. Jimmy Wanjigi to hold a firearms certificate. In a decree issued on the 23rd of January 2019, (522) issued to Jimmy Wanjigi and reinstated it.
Certificate number
9522. So the court has reinstated this firearm certificate, revoking, quashing an attempt by the Firearms Licensing Board to revoke it. Quashed, told, finished. Then Mr. Jimmy Wanjigi starts following up with the DCI to get back the firearms. Following up with the Firearms Licensing Board to get the licenses. In contempt of the court order in JR number 46, the Firearms Licensing Board is saying, who are you, High Court? You've quashed that letter. We'll validate another letter and revoke the same certificate. You think you know us? You don't know us. We'll show you who we are. You finish with the court, we'll start afresh. That's what they're doing to you. Contempt of court.
Just repeat that.
They decide to ignore the court orders issued and decide that you've revoked our letter you've quashed our letter revoking Jimmy's certificate. Fine. We will revoke it again. And we proceed to revoke it again. In contempt of court, they are telling the court, you think you know us. We have many tricks up our sleeves. You revoke this one, we issue another letter. We inform even verbally that we've revoked again. That's contempt of court. And Your Honor, for good measure, we filed an application for contempt of court in JR number 46 against the chairman and the members of the Firearms Licensing Board. They are treating this court with disdain.
That's JR number
46 of 2018. We filed an application for contempt this morning. And that board is the complainant in the proposed charges. That board that participated in the High Court proceedings, JR 46, they are the respondents. They have now become the complainants and are asking the court to prosecute Mr. Wanjigi. How ridiculous. They have not complied fully with the orders issued by the court. Now they are seeking to revoke again the license, the certificate, and saying now the guns that we had licensed on your certificate, you are holding them illegally. You should take plea for possession of firearms. And as my senior says, no notice, no invitation, no meeting. Those are questions we want the High Court to address. Let the High Court assert itself on if it gives an order, a person can decide to be clever by a half, by doing something to countermand those orders, not to facilitate the enjoyment of the orders. That is what we're going to invite people to do. By looking into the conduct of the complainant here, who was the respondent in JR 46. That is the injustice being meted against Mr. Wanjigi. We don't allow this court to be dragged into the act of disobedience, disregard, dishonor, the rupture of our constitution that the respondents do every day. That is their stock in trade. To them, court orders are inconveniences to be obeyed, to be complied with, as and when they think fits their daily bread or their daily need. Not to put order in the society and to anchor the rule of law as part of our democracy. Take that invitation. And Lady Justice does not entertain judicial malingerers. We have judicial malingerers before this court. They need to be taken to the appropriate forum to be punished. Punished to assert the authority of the court. And it becomes a lesson going forward that when the court speaks, we all put our fingers down and listen and bow in honor. That is the invitation. The final point is in regard to the second proposed accused person. Mr. Kibe, who as he sits here, they've committed the worst acts of torture that can only be done in a police station. And they almost attacked, and somebody was intentionally overnight targeting the most private parts of his body to squeeze and to torture. And the court can take note of that. Should order should be taken to hospital. He's not been seen by any medic. The people who tortured him are in court. His offense to the Jimmy is aid. That's the offense. So when Jimmy suffers, his aid must suffer. I've this read even myself as his lawyer. I may just be dragged into it. So the court should take notice. In regard to Mr. Kibe, please order that he goes for treatment before he can even seek to participate in any proceedings involving him. I'll leave it at that. Thank you very much.
Yes, Mr.
Yeah, make the following remarks to you respectfully. I associate myself fully with the airport submissions of my land friend, Senior Counsel Paul. And my land friend, Mr. Willis from Kenya. My Lord, what is an issue here is that use of power, conspiratorial power, investigatory power, and my Lord, this is not the first time we are coming before the court. Because of abuses lost by those in power, executive, investigation, and prosecution at all. It is a Christian hymn that you have been singing for the past 60 years. If you may permit me, Your Honor, to mention to you respectfully, what has happened to Jimmy Wanjigi is precisely what happened to his father. His father. His great father is my neighbor. And I recall one day, I woke up very early in the morning because I was required to go to court in the court of appeal. And my late dear wife knocked at the door of the bathroom. She said, "Look, you better rush to Wanjigi's home." The General Police have invaded the home. I rushed there, half naked. I had on a towel tied around my waist. They were harassing the family for upholding the rule of law, for upholding human rights. Your Honor, the background is charges before you. As my handprint has carefully pointed out here, it is quite clear valid court orders have been disobeyed. When we were at the police station yesterday, in the office of investigation, we were in a tiny room. Mr. Wanjigi was there, his wife, and his little children. The reason why we had gone to that police station had nothing to do with the gun offenses at home. Absolutely nothing. Absolutely nothing. It was quite something different. My friend Mr. Otieno, Willis Otieno, was able to give the background to the matter. And we convinced the senior officer was investigating the matter. They shook hands that will come another day. Out of nowhere, a senior officer came to forefront. What's the name of the police officer? Investigating officer? Son, Mr. Son. He was reluctant even to give his name. That's why I'm asking why he came out with a story about guns. It was clearly an afterthought. And it was clear that they were trying to find a way of keeping this Wanjigi in police cell for a night. Your Honor, what I observed most objective and contrary to administration of justice. Mr. Wanjigi was handcuffed in the presence of his little children, in the presence of his wife, clearly trying to demean Mr. Wanjigi as head of the family. And the law is very clear on handcuffing. You only handcuff an individual when you have evidence that he is likely to escape. Mr. Wanjigi himself and his little children and wife had gone to that room voluntarily. And there was no reason or there was no way Mr. Wanjigi would have escaped from the country at all. Is Mr. Trump full of venom, full of malice, trying to demonstrate that has got the power and authority to do anything he can under the criminal constitution. Handcuffed in the presence of his children. Your Honor, this is not what we fought for. We are going back to primitivity in administration of criminal justice in this country. The 2010 Constitution was to establish an environment under which we do things in a civilized manner, not in a crude, primitive manner at all. You cannot go ahead and handcuff an individual in the presence of his little children, in the presence of his dear wife. What you are doing is wrong, and that must be condemned. In the strongest possible language. Your Honor, may I remind you very respectfully of our 2010 Constitution. We have items in our 2010 Constitution which are dear to the public. Constitution. The common law which you have established, which is part of the law of this country, common law in England, is part of the law of this country. Has established that the court has inherent power To stay proceedings if it is demonstrated that there is abuse of process, which my able-learned friends have established before you. Your Honor, if you may be kind enough to allow me just to read it to the court. A stay should be granted where compelling an accused to stand trial would violate those fundamental principles. That is, Your Honor. Is illegalities have been committed. There have been constitutional violations. That is an abuse. That would be ridiculous. May I continue to read, Your Honor? A stay should be granted where compelling an accused to stand trial would Wanjigi lost his dear father a few weeks ago. Let us not pretend to be something else. We are Africans. We have our African customs. We have our own culture, which we respect. A person losing a father, Your Honor, is a great blow to the family. The family is still in mourning the death of a departed senior Wanjigi. Mama has been affected badly in health. The children no longer have someone they can call Papa. In our late 80s, have someone whom she can lean on his shoulder. That's a common sense demand that an African government should take this into account. Before arresting the son and bringing the DPP proviso that before he can charge an individual, he is at liberty to take other circumstances into account. This country, as I know from my public law review, does not have the law of mandatory prosecutions at all.
Yes,
we do not have it.
The council.
This country does not have.
Just a minute.
Sorry, Your Honor. I apologize. Would you rush to court immediately when you still mourning the death of his father? One was given a livelihood, shelter, education, and etc. The father Wanjigi, a respected individual, a man whose home I could freely enter and talk to him without notice. And he could freely enter my home and talk to my home without notice. Serve this country at the highest possible level. Director of Criminal Investigation, Director of Settlement.
Director of?
Of Settlement. At one time, he was the chairman of our Agricultural International Show. A renowned politician. Respected. Member of Parliament for Kamkunji. A cabinet minister, respected. He died at the age of 92. Our active media is shaken. Writes very long stories, very long articles on him, paying respectful tribute to the work he has done as a pillar of the Kenyan nation. No single word of condolence to the family from the highest office. You want to be kind enough to write that down. No single word of condolence from the highest office. Just as my wife, when she died, I received no single condolence from the highest office. A poor woman who had worked for the nation very hard. I'm saying these things to demonstrate, Your Honor, that the charges before you are not brought in good faith at all. I'll go further and make this alternative submission to you, Your Honor. A person who has served the Kenyan nation so ably, so energetically, so honestly, has obeyed the law of the land. His legitimate expectation when he dies is that his own children, his own widow, would be treated fairly, legally, given respect, as he has tried to uphold the rule of law in the country. That has not been done. Your Honor, if I may now continue. Your Honor, may I refer you to page 7, page 6 of that? Just a small position again. I'll read. A stay typically takes the form of an order that an indictment remain on the file with the instruction that it not be proceeded with. A stay is not technically an acquittal, although for all practical purposes it may have the same effect. The revival of a stayed prosecution without the leave of the court is likely itself to be considered an abuse of process and to be stayed accordingly. Your Honor, the reason why I'm reading this to you, again respectfully, is to show you that you have the power and the authority to reject these charges. On the other hand, you have the power and authority to order a stay. And that will be the end of the matter. This matter will need to be revived by anybody at all. Finally, Your Honor, I would refer you to another important aspect. And against an individual as in accordance with the Constitution. Your Honor, what I'm saying, human dignity in this particular matter of here. The title of it sums up what I would like to say to you. Your Honor, I wrote a letter. I'll give you a copy. Don't wish to take too much of your time. I've seen that your court is a lot of work, but I would like you to go through it. Your ruling in this matter. We have process in the country. Those processes have been found in the executive arm of the government. and some second-rate politicians. Who would like to water down the 2010 Constitution. They are not happy with it. Can only be upheld and continue to be in existence faithfully and firmly if the course of law remains firm. Boldly firm. The case Jimmy Wanjigi success. What else he has gone through is a test case. That we either go back to the old administration when President Moi was in power, when we were harassed, thrown into detentions, we had extrajudicial killings, and etc. Or you sitting there as a judicial officer, you stand firm so that the executive does not take you for granted. They do not assume that they will come before you with any charge and you will uphold that charge and you will call upon someone to plead on it or not to be plead on it. You will say to them, no. Given this background, I'm throwing out this charge. Given this background, I'm making an order for a stay. Your Honor, if you show any weakness that you will allow anything that the prosecution brings before you, Your Honor, you're destroying the Kenyan community. And the posterity in the Kenyan nation will blame you. We are where we are at the moment because of this 2010 Constitution. We fought for it. People were killed for it. People were detained for it. People were sent to prison for sex charges for it. Rise to the occasion and uphold this Constitution by saying that the charges against Wanjigi are hereby stayed. Or alternative, the charges hereby against the charges hereby against Wanjigi are thrown out into the dustbin. people. They are clever. In a sense that is objectionable. By hearing a voice of a lady, don't shoot me, don't shoot me, don't shoot me. The law of proportionality in arresting individuals. The law of proportionality in carrying out had been abused. You sent 40 askaris to the home that has been aggrieved that he has lost his father, his head of the family, to look into something ridiculous. That concludes what happens in a banana republic. You have to sort out everybody to carry out searches when you know there's nothing there and you come up with nothing. Ridiculous. Dishonesty. No wonder that I heard the voice of Wanjigi saying that you have carried out a search here before and you found nothing. And you're going to carry another search, you'll find nothing. Your Honor, may I say all these things are happening to Wanjigi, if you may pardon me, because of our own weakness in the judicial system. Let the judicial system speak the way Lord Dennis spoke. Let the judicial system speak. Courage is called for. And you have been given opportunity to demonstrate that we who are associated with and the bench will exhibit courage and throw out these fake charges. Do not uphold them. If you do so, Your Honor, you will be taking us back to the boys' days. Thank you.
With the submissions by both Senior Counsel John Hamenoa and Paul Mwite. With regard to the matter before you. Senior Counsel John Hamenoa, so refreshing to hear.
Thank you very much. Thank you.
The lady was screamed, "Don't shoot us, don't shoot me." Is in this courtroom. She is a wife of Wanjigi, and her children are with her. Therefore, Your Honor, you have some singular opportunity to make or contribute to criminal jurisprudence in our country. By saying no to impunity, yes to the full application and observance of the rule of law, which is our guiding principle in this country, and the Constitution 2010. We sat patiently here when you were taking other pleas, and sorry I had to rush and attend to a cremation of a friend's mother. So I thank Paul for holding brief. I think you've been given a list of counsel who are associated with this matter. It's an impressive list. These are not men and women who are seeking vainglory or showing political support to Jimmy Wanjigi. But these are senior citizens who want to call out impunity. And although some be political leaders like Paul himself or my brother Eugene or Marlon, and I think our sister mother was also on record, but they also are senior, they're also members of the legal fraternity. And if I can quote what my colleague Eugene said yesterday when we went to Kamukunji police station, the judiciary is our last line of defense if we are going to still remain as a country under the rule of law, in a country that is a democratic state. Therefore, we intend to move with speed and call out the men in the executive, all in utter disregard of a restraining order, went ahead and abducted. Your Honor, a gentleman in your presence abducted. Your Honor, a gentleman in your presence abducted. Your Honor, a gentleman in your presence